Okay. Is it ready? It's okay. Okay. Hello everyone, welcome to our event today, and we are very happy to host all of you. Today we have special guest, Professor Shai Dothan from University of Copenhagen, and we are going to talk about his, I think, forthcoming book from Routledge, Elitist Power Struggles and Law, and how are courts dealing with the concentrated and also diffuse interest, and how the courts are supporting diffuse interest as well. So it was today's lecture, and Professor Shai Dothan will have 25 minutes to speak, and then we will have a Q&A session. Thank you very much for your participation.
Throughout most of human history, it was clear that all the political power was concentrated in just a few people. Emperors, kings, princes, most of the masses didn't have any political influence. Slowly, starting around 200 years ago, there's a process of democratization in which the power goes to the masses. More and more countries are transitioning towards democracies where more and more people are voting, and it's gradual and it's slow, but that seems to be the direction in which most of the countries in the world are going. Then the literature started to deal with another problem, an opposite problem to the one that was present in the past, and that was the problem of the tyranny of the majority. So what happens if most of the people are starting to harm the rights of minority, for example? And that seems to be the current across the literature until one great economist, Malcolm Olson, changed that. And Malcolm Olson said, even in a functioning democracy, most of the real power is not held by the masses, by the diffuse interests, how we call them. It's held by small concentrated interests, small groups. Why is that? Why is it that a small group can succeed when democracy is based on the idea of one person, one vote? Everybody votes, so why is it not the majority that calls the shots? And his argument was simple. Within a small group, free riding is not possible. Everybody works together. And this gives them a lot of power to change politics and to constrain politicians. Let's give an example, which I give at the beginning of the book. In the sugar market in the United States, only very few families control almost everything. Let's say a very generous assumption, 300 people control a market that brings to their pockets more than $3 billion a year in subsidies, in earnings that they get because the prices are high, because there are tariffs, all the tricks that are basically giving a lot of money to this small group. Now, for every one of these person in the group, on average, it's worth $10 million every year. This means that they can dedicate their careers to make sure that politicians do exactly what is beneficial to them. If you look at the general public, there are 300 million people in the United States. On average, they only lose $10 every year because of the sugar budget. Every person loses $10 a year. Now, for $10 a year, you're not going to change political alliances, you're not going to try to bribe senators, you're not going to go on demonstrations, you're not even going to write a letter to a newspaper. You're not even going to be informed about it because it's not worth your time. And because of that, small groups control market after market after market, affect politicians, and they have most of the power. That was the argument that was made by Malcolm Olson. And when I learned this argument, I thought to myself, it's convincing, it's probably true some of the time, but there must be exceptions. I face that a lot in Denmark from my students. I teach them this argument, and I say, well, we are not all suffering in abject poverty and giving all power to small groups. We have a power to succeed. And that's why I was very happy when I read a book by Gunnar Thorbrad, who is a Harvard Business faculty professor, who argues that diffuse groups sometimes do have power. Why do they have power? Because even though they have free riding, they have the possibility to act as a group in a way that looks legitimate. They are not just representing their own interest, they are acting for the group. And this gives them power to affect politics. Now, this is the founding moment for me of this book, The Elite's Power Struggles and the Law, How Courts Support Diffuse Interest. It's published by Routledge. Actually, the official publication day is today. I just got pre-copies a few days ago. And what I do in this book is I try to explain what is the role that courts play in this situation, in the dynamic between diffuse interest and consolidated interest. And I argue that courts are helping diffuse interest. They can strengthen them. They can improve a position vis-a-vis consolidated interest. And in the lecture today, I would like to make this argument in 3 stages. So first, I'm going to speak about the role courts generally play. Why is it that they help diffuse interest? Then I want to focus on national courts, mostly national Supreme Courts, but it applies across the board. There are examples in the book of a variety of courts. Then I will focus on international courts, and then I will just say a few words of conclusion at the end. Let's try to understand why is it that courts help diffuse interest. If we follow the argument of Marco Orson, the key thing that is preventing diffuse interest from succeeding is that they are underinformed, they are undermotivated, they cannot really affect the political branches. Why is it likely that courts will change that? After all, most judges are from the elite, they are from the consolidated interest. I mean, there are statistical facts. They study in the best schools, they usually are quite affluent, they earn very well before they become judges, they earn well as judges, and they come from, in every society almost, the highest echelons of society. And it's also, I think, reflected in the judgments, that they are often supporting attitudes, principles that are supportive of the elite. So why is it that they will support diffuse interest? So my argument is divided into 2 elements. One is an element that tries to see what are the pressures that are pushed on the court before it makes its decision. And here I argue that courts have a strong incentive to side with diffuse interest and to go against consolidated interest, because if they don't do that, they're going to lose public support. So courts are relying on the public confidence in their judgments. They need the support of the public to succeed, and because of that, if they go against diffuse interest, there's going to be a backlash against them. Now, sometimes they do that. The famous example in history is probably the Nothner judgment and other judgment of the court. It was supporting big business at the expense of most of the public, but as we saw, there was a backlash against them eventually. So eventually the court will be pushed to decide in a way that supports diffuse interest. But I know this argument may be not sufficient for many that would say we may have to wait sometimes decades until the court changes its behavior. So over these decades, what happens? My argument here is that even if the court is going against diffuse interest, it often actually ends up serving them, because it creates a public discussion, public deliberation of the issues, and this makes diffuse interest more informed, so they get more information, and they are going to fight for the rights of before as well, and it gets them more motivated, because they can use the judgment as basically some form of a rallying point, battle cry to support the rights in the future. So the role that courts are playing is, first of all, many times they will support diffuse interest because they are pressured to do so, even against the ideologies of the judges. And second, regardless of what the courts are doing in the judgment itself, everything that happens post-judgment can actually help diffuse interest become stronger. Let's see how this plays out with national courts. Now, if you look at national courts, I think a good place to start is to try to understand what is it that national courts are supposed to be doing. What is the justification for the intervention in the political bodies? And the most famous book about this subject is probably Democracy and Distrust, a book by Jean Monnet, that says courts are necessary because democratic bodies don't always function properly. There is problems in the representation of what you call discrete and insular minorities. So these are minorities that are too small to be in charge, they can't really form a coalition or become a majority, but also suffering from prejudice that makes it difficult for them to create deals with the other parties that are bigger, and that means that they have much less political power. Now, very soon after this book was published, Bruce Ackerman, a famous law professor from Yale, published a paper and says, I agree with the principle of Jean Monnet, but you need to be aware of the fact that the democratic deficit, the problem with the democracy, is not just with discrete or minorities, it's also with diffuse groups, according to Marco Rosso's argument. And I completely buy into this argument, and I say that courts are there to fix what needs to be fixed in a democracy. And if the problem is that diffuse interests are not getting enough power, then courts can help to fix them. So we have kind of a normative justification to do it. But do they actually do it? Now here, there are examples from different courts, but I also try to develop a theory of what is it that courts are actually doing. And here, I found very useful a paper by Landis and Posner, two very famous professors from the University of Chicago. And this paper says the following. If you have a democracy, you're going to have switching of power between parties. Once a party is out of power, it cannot really come through with the promises that it gave to interest groups before that. Now, if interest groups want the party's promises to continue after the election, they need an independent court. Because the independent court is going to make sure that the compromises that they have with the incumbent government will sustain themselves even after this government loses power. So if you have, for example, a Democratic president like Biden, he has agreement with interest groups, he needs to know and he needs to be able to commit to them that some of these promises will hold water also when Trump gets elected, for example. And that's exactly when independent court is helpful for this situation. And because of that, the court has a role in preserving deals with interest groups. Now, my claim is that this is mostly relevant for diffuse interest groups. Concentrated interest groups have a very strong hold on politics because they give donations in billions of dollars and they control the politicians in a very specific way. But these diffuse interest groups that need the independent courts, and that's why they have a symbiotic connection with them. There are situations where the court behaves a bit differently. And that's a situation where, for example, you have a hegemonic group that loses its power and it strengthens the court in order that the values of this hegemonic group will preserve themselves even later. This is a theory that was created by Professor Van Hirschen, and his most convincing example is the Israeli example. I think that's also the reason why he started to write about that. I myself an Israeli, and I wrote my first book about the Israeli Supreme Court, describing a similar phenomenon, but from a different perspective. So Van Hirschen is saying there was a shift from liberal elites in Israel that were about to lose power. They strengthened the Supreme Court, and the Supreme Court was supposed to put in check the other, more religious, more traditionalist elites that were coming instead of them, and gaining power. I think there's some truth to this argument, but it's better to look at it from a perspective that puts the court as a being that has a life of its own. So courts are trying to build their power, what I call reputation, and in order to do that, they need to preserve their compliance with the judgments, and they need to challenge themselves by issuing more and more difficult judgments. The problem is, if you do it for enough time and you are detaching yourself from what diffuse interest groups want, you're going to lose the support of the public, and eventually you're going to start getting no compliance with the government as a result. And that's exactly the situation that we see in Israel. And in several other cases of retreating democracies, I think it's a similar condition, and this is a condition that is getting worse in cases that I deal with in a specific case study in the book of prosecuting politicians. So in Israel, for example, one of the reasons for the last phase of this democratic erosion was that there are criminal charges against Prime Minister Benjamin Netanyahu, and I think that's part of the reason why he started a vendetta against the courts, which led at first to a very lively discussion in the public with potentially some beneficial consequences, because a lot of people that were not interested in politics started to get very, very informed and very involved. What happened then was, and this may have been one of the reasons for that. I say specifically in the book, but I'm completely agnostic about it, whether there's a causal connection that right in this process, beside the war with Gaza, with the massacre of 7th of October, and this completely changed Israeli society. I mean, there's been a 2-year war, a lot of suffering and death on both sides, and that's where we are today with a system that is really, really struggling. In addition to, these pressures that are pushing the courts towards diffuse interest, I mentioned what happened after the court issues its decision. And here I have a series of case studies in the book that shows that it doesn't so much if a court is deciding against diffuse interest or for them, the process of public deliberation is ignited and leads to positive results. So if you look at the intuitive case, if you look, for example, at Brown v. Board of Education, a judgment against segregation for the rights of blacks, it's a good example of a court taking the lead, supporting weaker groups, and this gave inspiration to the entire human rights movement in the United States, and that's a very, very positive development. That's very intuitive. Doesn't surprise anybody. If you look at the opposite case, for example, where the court issues Bauer versus Hardwick, the judgment that allows the criminalization of homosexual behavior, this is a judgment that looks like it's against this minority group, but what happens then was a huge influence on all of American society. So in the short term, you have gays going out to the closet, going on demonstrations, donating more money, creating associations. Then a series of legislative changes where state after state is decriminalizing homosexual conduct. And then eventually it goes back to the court again. In Los Angeles, Texas, they decriminalize homosexual conduct as well. But the interesting is what happens in the middle. So once the court issues a judgment that goes against a certain group, this group uses this to come together, market support, and start a discussion. And this discussion usually ends with a supporting diffuse interest. If you look at international courts, that's a slightly more complicated story because there are so many different kinds of courts. So let's divide it into 3 kinds. The first kind is courts that follow the classic Westphalian paradigm, 2 states coming together to the court, one against the other. The court is somewhere between a mediator and an arbitrator between them. In this situation, I don't have anything specific to say about diffuse interest. But what I see is that if you look at the international courts in recent years, they are slowly shifting towards different paradigms. So courts that are following what I call the hierarchical paradigm, the court that basically decides to give orders to the states, you do that, you do that. And these courts, like the traditional view of the European Court of Human Rights, they are great allies of diffuse interest because they need the diffuse interest in order to get the support, make sure that these judgments are actually complied with. And that's why, again, we have a similar situation as with national courts. But what I see in many international courts is a shift towards an even more connected paradigm, which I call the network paradigm. And that's what we see, for example, in the European Court of Human Rights, being at the middle of a network that involves civil society organizations on both sides. His dissertation shows one side of that. There are also the liberal side. And these organizations are fighting together, and this arena of deliberation is a very good thing because it makes sure more information goes to more people. When I did empirical research on the European Court of Human Rights, qualitative research, what I try to do is I try to look for an angle where I could really understand how this network works. And what I did was I found a website where they published reports on states that were filed according to the Rule 9.2 procedure, basically allowing states to allowing NGOs to criticize states for non-compliance with the court's judgments. And what I did was I coded everything on the website, and I tried to see if I could determine whether these NGOs were focusing on the most important issues, the most severe violations. I basically did a lot of separate attempts to see if they focus on issues that matter the most. I won't say much more about it now. And what I see is that they do. Sorry? Okay. They do focus on these issues. How much time do you have?
It's almost half an hour.
Okay, so I will speak for 2 more minutes and we'll close it. So these organizations are focusing on the issues that matter the most. Therefore, the network seems to work very well. And what I see is that the courts are actively building this network, so creating procedures like the website that I checked, acting together with the NGOs, giving them information, having leadership programs, and that's something that I see that is working very well. In the book, there's a case study about the internet. The main thing I want to say about that is that in addition to having judgments that directly support diffuse interest, you can also see judgments that make sure that national courts, regulators, and the court itself will have a continuing role and build this network later on. So, following all these reasons, I see that national and international courts both support diffuse interest, and they this makes them justified, I think, to issue more demanding judgments when they do that, to widen the margin of appreciation and require more from states when they do that, to use expansive interpretation that basically allows them more flexibility to do that, because they have an important role to play. And that role is, changing this democratic failure that makes the diffuse interest inferior and giving them more power.
Thank you.